guys, it's Kathy. I hope everybody's doing well today. End of the week, Friday, lovely Friday. Nice, that I don't have to go to my one job tomorrow. I'm off for 2 days, and I'm excited about it. So I thought that I would take that excitement and make some court videos. This first clip, if you know, you know. If you've seen my prior videos, there's one thing in this courtroom that I have an issue with, and nothing happens in this clip. We're not going to see a court case or anything. All I'm doing is showing you Giles's courtroom as it is today, because if you know, you know. There's something in this room that just does not belong here and is always here. So, I think I'm going to just take some pictures of Giles's courtrooms every once in a while and remind you guys that it's always there. Here we go. Yep.
Yes.
That's today.
Anything else?
No.
All right, thank you.
Thank you. Have a good day.
You too.
When will they move it? When will they get it out of there? I don't know, but we're going to keep watching it. We're going to keep watching it. All right, on to some real cases. So with real judges doing real work, hard work that I'm glad I don't have to do. Unless I had a taser. Now, this woman here, almost every case we watch for fun on these channels would die for to get what she's getting here. And she is just absolutely not happy.
What's your name, ma'am? Ms. Boykin, this is Magistrate Chartea. Ms. Boykin, not only do you have 3 criminal matters, but you also have a misdemeanor matter. Misdemeanor matter where you failed to show up at a prior court hearing. What I'm going to let you know is I'm going to tell you what that misdemeanor matter is. Do you understand that?
Yeah.
Okay. Nobody's going to have to pay any money for you to get out of jail on this misdemeanor matter. The ticket number is, I'm going to call it the warrant, is P1069082. The misdemeanor is disorderly conduct. Maximum penalty is up to 93 days jail and or $500 fine. Understand that, Ms. Boykin?
Yes, ma'am.
I'm going to enter plea of not guilty. Court date is August 18, 2023. Pre-trial in front of Judge Yancey. Ms. Boykin, you have a right to remain silent. Anything you say, orally or in writing, it can be used against you in a court of law. You also right to an attorney. Have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights?
Yes.
Okay. Ms. Boykin, you have 3 cases. I'm going to let you know what they are. First case is 200, and they're going to be all the same court date. So first case is 200-4471-401. The other case is 230-4462-301. Last case is 200-5721-401. People's State of Michigan versus Shaikia Boykin. Please say your full name, Ms. Boykin. Thank you, Ms. Boykin. You have an attorney, ma'am? Go ahead, counsel. Thank you. I'm going to enter plea of not guilty. Court date is, for all 3 matters, September 12, 2023. It is a pre-trial in front of Judge Bryant. Ms. Boykin, do you understand that court date?
Yes, ma'am.
Thank you. Ms. Boykin, you have some bond conditions. Let me tell you what they are on all of them. Okay. One is You're not to have any contact with Michelle Bentley. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand that, Ms. Boykin?
Yes, ma'am.
Okay. Also, Ms. Boykin, okay, you're not to go to the location of 3700 Joy Road. It's a Citgo gas station, City of Detroit. Do you understand that?
Yes, ma'am.
Also, Ms. Boykin, let's see, what else? You are, again, not to go to 3700 Joy Road. No assaultive behavior on your part while any of these cases are pending. Do you understand that, ma'am?
Yes, ma'am.
Now, on all three matters, you have failed to appear in court. Okay. On one is from November 2nd, 2022, the warrant was issued for your arrest. You did not show up for court. We have one from 2023. You just picked that up. There's no capias. We have this other one from 2020, okay, or 2005. I apologize. On that one, you failed to appear in court on November 2nd, 2022. All right. So, Counsel Ragnan? I'm sure there are, but go ahead.
I believe that is the community $2,500, 10% cash bond. But most importantly, CPS Tether was only less. It also hasn't shown up in every case that she's had, she's been guilty of all these crimes. She put on probation initially. He has multiple violations of probation in each case that she is.
Okay. The audio is really bad there, I know. So I'm going to try to tell you what I think that maybe I heard. She got a real low bond on all of them. And I don't know if she did it, if she got out in the past or not on this real low bond, but she was supposed to get a GPS tether and she did not. And then she had some court cases that she was supposed to go to, and she never appeared. She just failed to appear. And then what he's saying is she has multiple probation violations. Now, I don't think he gets into what they were, and I can't hear what they were, but she doesn't come to court, and her bonds are always ridiculously low. Assaultive behavior. Multiple counts of assault and violence. I didn't hear what he said there, but
Your Honor, she has a caregiver suffering from mental illness. There's 3 matters in front of us today. Habeas is on 2 of them. One of them she's never been arraigned on. Her bonds were $100, 10%. I believe those were meant to be affordable, $10 each. Unfortunately, she has to go to the kids, lifelong resident. So I am respectfully asking the court to consider a high verdict. The court is not inclined to do that. Or however you understand, I don't believe the tether is necessary. I know that she didn't fill up the court order. I know how that looks to the court, but our office does have all updated contact information. We call the consultation. She knows the importance of that and what will happen if he is not back at court. We also have, so I'm respectfully asking the court.
Okay. appear that she really obeys the court orders of showing up for court. She's been given multiple chances. Okay. So the case number, last four, 200447141, where her bond is $100, 10%. I believe that's unaffordable. Is that correct, counsel? Okay. Well, I'm going to leave it at that. That her bond is $100, 10%. Sure. Last 5 digits, 71401. So bond is $100, 10%. It's unaffordable. And so that means she's going to get a court date for Monday. That will be July 24th, I believe. Yes, July 24th, 2023. Okay. Apparently she doesn't show up, so flight risk. So you will go at 9 o'clock in front of Judge McConigal this Monday. Okay. Ms. Boykin. For that case. For the other case, which is the KPS, last 5 digits, 21401. Okay, bond on that was $100, 10%. I'm going to keep it that, along with the bond conditions. That's going to be an unaffordable bond. Again, she will go in front of Judge McConigal Monday, 9 o'clock, for Judge McConigal to review the bond conditions in this case, as well as the bond amount.
Okay, so what's gonna happen to me?
Okay. Ms. Boykin, for the last case, it's the last 4 digits, 2301, which is a new case. In that matter, that's a retail fraud. She's already been at that location. Okay. I'm going to give her $100, 10%, unaffordable bond. And she's going to go in front of Judge McConigal Monday, which will be July 24, 2023, 9 o'clock, to look at the bond and bond amount and bond conditions. Anything else, folks? Ms. Boykin, you're having another court date Monday. You're going to go in front of Judge McConigal. You're going to go, you may or may not go in front of Wayne County, but you will Monday, you will go in front of Judge McConigal, who will look at your bond.
May we make it clear to Ms. Boykin?
Go ahead.
She pays $30 and she does not have, she can get out, she does not need to her court date until Monday.
Okay. Go ahead.
Go ahead, do it.
Ms. Boykin, this is your attorney speaking. Please do not say anything at all. Your bond is $10 on each case. It's $100, 10%. So if somebody can pay $30 for you, you can go home today as long as you have no other holds and you won't have to wait until your court date on Monday.
$30?
Yes.
$30?
Yes.
I don't know nobody I can call for $30.
Okay. Okay, Ms. Boykin, then you'll see Judge McConigal Monday at 9 o'clock. Thank you, ma'am. No. Thank you. All right. ADC.
$30. $30. My Lord, we have people in here whose bonds are ridiculous. Ridiculous. And she had a $30 bond for 4 cases. 4 cases. 4 cases that she failed to appear on before. Assault, retail theft. Her bond is $30, and that she just does not like. Oh my goodness. All right, here we go. Over to Elizabeth.
Defense is that he would be eligible for the
Someone Tether's going off, so please make sure you go out into the lobby. You may have to contact your Tether agent.
I thought that was hilarious. We're just going through court, la di da di da, boring, 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 boring. Someone's tether goes off. All right, this girl is cute. Um, she's like, yeah, it was probably me. I probably did it. You're right. I've been known to do something like that, so I left her in.
Step up just a little bit. It's hard for that to pick up your voice if you're too far. There you go.
Yes,
Let's
sir.
see, Ms. Cornish, you can hear me okay?
Yes, sir.
All right. You feeling all right today?
Yes.
Other than being in jail? Okay. Let's see. The other day, a couple days ago, you got this public intoxication. You have a few options. You can plead not guilty. If you don't think you were guilty, you can plead not guilty to this. You can set it for trial, or you can have time to talk to an attorney. I would set, let me double check real quick. So I would set a PR bond on that case of $500. You understand what a PR bond is?
Not really.
A PR bond is essentially you sign some paperwork saying you promise to appear, and that if you don't appear, you're on the hook for that $500. You don't actually pay that $500 now. You sign the paperwork saying you understand you have to appear, and if you don't, then you're on the hook for that $500. So if you think you're not guilty of this, you can plead not guilty. I can set that bond. If you want to plead guilty or no contest, you can do that. The total is $484. You do have credit of $300. That would leave you owing $184, and I would release you to appear here on the day after you get out, which looks like it would be today. So you would need to come to court on Monday and set up a payment plan. Or you could always just show up and pay the $184, but if you can't, then you would need to come here and set up a payment plan with us. What do you want to do?
Probably set up a payment plan because I go to like the plasma center, like
Okay.
to the and stuff, and like the one I go to, they give you 30 for the first day and 90 for the second.
First off, someone needs to tell that other lady that she can sell her blood for $30 and get out. Second off, this woman is saying, I'm going to sell my blood to get out of this, to pay. I'm going to go sell my blood to pay this. That's horrible.
Every day, like every time I go, like this is supposed to go 2 times a week. So I can probably do it like that.
So Ms. Cornish, how do you want to plead to this?
What do you mean?
Do you want to plead guilty, no contest, or not guilty?
Guilty, you know, y'all said, oh, you caught me in public drunk, then yeah.
It's if you don't think you're guilty, you don't have to plead guilty, but you can plead guilty.
But I probably am because I'm known for, you know, I'm a big drinker.
Okay, so you want to plead guilty?
Yes.
Okay,
That
I'll
sounds
accept your
like
plea of guilty. That total is $484. I will give you $300 credit. That is going to leave you owing $184. It doesn't look like anything else is holding you, so you should be released today. They're going to give you a map to the municipal court. We need to see you Monday. Like I said, you can either come in and pay it all. I'm sorry, what?
About what time?
By 2 p.m. Court is at 2 p.m. So really you need to be here about 30 minutes early to get checked in, and then we can see you at 2 p.m. and you can set up payment arrangements. Remember, if you don't show up, what do you think happens?
You come back to jail.
Yeah, a warrant issues. You come back to jail. Also, then you owe more money because it tacks on $50 to the amount you owe. Just come in on Monday. Be here about 1:30. Like I said, they'll give you a map. Be here about 1:30. We'll set up the payment plan and you'll be all set, okay? All right, we'll see you Monday, okay?
Okay, here's probably what's going to happen. She owes $184. She can earn $60 a week by selling her blood. So she does that for the next 3 weeks, never pays that other $4, and we see her next year in jail over $4 because she didn't sell enough of her blood.
And thank you.
Okay, have a good weekend.
The first of those that I'm going to call for trial is Scott Sherbert versus Intercity Transit. That's 36982. All right, Mr. Sherbert, I see that you're here. And then I have Mr. Adams from Intercity Transit. Okay, so before we start the trial in your case, I will just sort of give you some information and an outline as to how this will proceed.
Judd talks a lot. He just does. He talks a lot. He tries to explain every single thing to everybody in the hopes that his court runs smoothly and everybody understands what's going to happen at every point and everybody understands what he wants. Nobody gives it to him. I mean, he does. The civil cases today, people are just yelling at each other, and this poor guy, he's like, I explained this to you before. You only talk to me. And when he asks a question, people just answer whatever they want to answer, whatever they feel like saying to him. They never answer his questions, and it's the poor guy. He's steady and patient, but he does talk a lot.
This will apply to the other case that's here for trial too. So the plaintiff in the case, I'll swear both parties in, and then the plaintiff in the case, in this case Mr. Sherbert, gets to present his case first. So that when I say present your case, I mean testify about the case. That means your version of events. And I will also consider any exhibits that you filed by the filing deadline, which was last Friday. And I would also consider any witnesses you may have who testify in your case. After the plaintiffs had a chance to present their case and give me their version of events, then it'll be the defense turn and the same process. I'll hear any testimony. I've received any exhibits and I've already reviewed those. And if there's any testimony from any defense witnesses, I'll hear from them. After I've heard from both sides, I'll make a decision. Now, the way I apply this is the plaintiff in the case has the burden of proof. That means the plaintiff has to prove their claim by a preponderance of the evidence. That means the greater weight of the evidence. I will tell you whether I find for the plaintiff or for the defense, and I'll explain the reasons why I made that decision. I'm going to ask you during the time the other party is presenting their case to not interrupt them. You need to allow them to tell me their version just the same as they're going to allow you to tell your version. I understand and expect that there is not agreement, because if you were in agreement about this, you would not be here. So please don't interrupt the other party telling me their version of events. I may need to stop you if I need to stop you to ask a question, and I would do that only because I need to make sure I understand your claim or your defense. So we'll get started here then with Sherbert versus Intercity Transit. So can I have the parties raise your right hands, please? And do each of you swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
I did.
Thank you. All right, so Mr. Sherbert, this is your claim. You get to go first. Go right ahead, sir.
Okay. Good morning, Your Honor. So back on January 18th, it was a rainy, wet morning, and I was heading west on Pacific Avenue. And I pulled around an intercity transit bus, pulled around to pass it. I then pulled in front of it, noticing that there was 3 cars already stopped at a crosswalk. Now, so I slowed down in the right lane and stopped at the crosswalk. And then I got rear-ended. The bus.
He assaults us with his nipples this entire video. I'm just warning you.
Didn't see me or was going too fast, I think, or something. And he rear-ended me. It's alleged that I stopped for a school bus, which was on the opposite side of the street. And I guess there's some law that you don't have to stop if the bus is on the opposite side of the road or something like that. But I didn't stop because of the school bus. I stopped because there were 3 other people already stopped in that crosswalk for some reason or another. I don't know. I couldn't see what they had stopped at that crosswalk for. So I wasn't going to risk blowing through that crosswalk when 3 other cars were stopped there. When I pulled around the bus, it's alleged that I cut him off and slammed my brakes on, which couldn't be further from the truth. I just pulled around him, pulled into the right lane, and had plenty enough time to slow down at the crosswalk. And then consequently, the bus driver rammed me. He hit me hard. He pushed me like 5 car lengths. And he was cited. He was cited for following too close for conditions. And I just want my truck fixed. That's all I'm suing for. We couldn't agree on a price. I dropped my price way down for my initial lawsuit, like in half, more than half. And they just won't, they didn't want to meet that price. And I don't know what else to say. I was stopped and I got rear-ended hard. So that's pretty much it.
Okay, then I'll let Mr. Adams tell the version from Intercity Transit's point of view, and then I'll make a decision. Mr. Adams?
Your Honor, Mr. Sherbert, we do agree with Mr. Sherbert that he was rear-ended, but as you state, we disagree with some of the facts from the case. If I could draw your attention to Exhibit 10, and that's a video of the incident and tells a story. Mr. Sherbert is correct. I wasn't there. He was involved. But sitting in the driver's seat of his truck, he doesn't have the full perspective of what actually occurred and why. I think in the video, you'll see the school bus on the opposite side stopped, to which the cars in that opposite lane stopped behind the school bus. But in the in the opposite direction where the coach is traveling, in the far right lane, the coach has a clear path to proceed through the intersection. Mr. Sherbert talks about a crosswalk, but as you'll see in the video, when he stops and switches lanes immediately in front of the coach, not giving the coach enough time to stop, around the cars that are stopped in the lane that he goes around, he's already through the crosswalk. So I think there's an inaccuracy there. Exhibit 9 is the dismissal from the citation. The operator was cited on scene, explained their story to include the video, what happened, their inability, their reasonableness in going through the intersection and continuing in the open lane of travel, and then their inability to stop in time after Mr. Sherbert cut right in front of them. That citation was dismissed, and that's in Exhibit 9. I think another misstated fact is, I think it would be completely different. Our liability decision, which we ultimately denied the claim and why we're here, we weren't following Mr. Sherbert. Mr. Sherbert apparently went around the coach and was in the lane adjacent to the coach as it moved through the intersection. So we weren't following him. He abruptly cut over into the lane right in front of the coach, quickly applied the brakes, not giving the coach operator enough time to stop. So we weren't following him. And then Mr. Sherbert did state that he had dropped his damages in half. And in good faith, we did make an offer, but we do believe that the denial is the correct liability decision, in that $0 for zero fault on the place of Intercity Transit, or their operator, is the correct decision in this case.
All right, pretend you're the judge. We can't see the video, but I think we all know what's on the video. I feel that this guy, and we've all driven around with this guy, just the bus was going too slow for him. He got in front of the bus. I believe he cut right in front of the bus. I don't believe he got over safely or anything. And then I believe that he slammed on his brakes. I believe that that's what happened. And one of the reasons I believe it is because of Cedric. He's like a robot. He's so, I don't know. He's just, here's the evidence. This is exactly what happened because it's in a video. I don't have to tell you what happened. But Scott just has been a jerk this whole hearing so far. So yeah, if I'm a judge, Cedric, you win.
And that the burden of proof from the plaintiff hasn't been met, sir.
And I'm not considering any negotiations between the parties in making a decision here. Certainly the parties, being able to discuss potential resolution shouldn't prejudice them during a trial. And so the fact that a claim was made, the fact that offers were made and rejected is not in any way going to figure into my decision as to whether or not the claim's been proved.
I wonder if he could have used that as defense, though. Or, well, I guess not a defense. He's the plaintiff. I wonder if he could have said, they know they're at least a little bit wrong because they did offer me some money in the past, but it wasn't what I wanted. That's why we're here.
Okay. So, Mr. Adams, I've heard your testimony and I've reviewed all of the exhibits that were submitted prior to today's hearing, to include the ones that you referenced, but also all of the other exhibits. Some of those exhibits do reference negotiations between the parties, and to the extent that I already explained, I won't be considering those, but I also see there's some evidence of the amount of damage that Mr. Sherbert is claiming was done to his truck. But overall, given the exhibits, the testimony that supports each party's claim and defense here, it's very clear to me what happened here. And I think the video submitted by Intercity Transit in their exhibits certainly helps to understand that. And Mr. Sherbert was hit from behind by Intercity Transit bus, and I think in most people's minds that raises an inference that's almost unshakable that automatically creates liability on the part of the party that was the following vehicle or the following driver. And in most cases, that's usually true, and that's probably why a citation was issued to the driver of the bus for following too closely. Following too closely is a rule of the road, and that rule of the road essentially says that a vehicle shall not follow closer than is reasonable, having due regard for the circumstances of the road on the roadway and the speed of traffic. And that citation was dismissed, and again, that doesn't control the decision here, because the issue of liability is separate than the issue of whether or not a rule of the road was violated. There are many other rules of the road, some of which are applicable here, but others that, they do not dictate liability in and of themselves. Another rule of the road involves moving a vehicle from one lane to the other, and that rule of the road says that the vehicle can't be moved left or right upon the highway unless that movement can be done with safety. And as is obvious from the video, the way this collision occurred is that Mr. Sherbert changed lanes and did so without signaling, and did so directly in front of a bus. And as Mr. Adams, I think, correctly said, the driver of the bus was not following Mr. Sherbert. Mr. Sherbert, in fact, cut off the bus in its direction of travel. That movement from one lane to another was not done with safety, and it wasn't signaled, not giving the bus driver no real opportunity to prepare for the vehicle in front of him changing lane. So what I find here is that Mr. Sherbert has not proved his claim. The collision, in my view, in fact, was precipitated by Mr. Sherbert's actions. And Mr. Sherbert's not entitled to any recovery because he has not shown that the driver of the intercity transit bus was in any way negligent. So my decision in this case is a verdict in favor of intercity transit.
Perfect.
All right, that'll be the decision of the court. I'm executing a written judgment to that effect, and that judgment will be filed by the court clerk and available to both of you later on today.
Yep, the big guy wins again.
Sir, the assault on my eyes by your nipples already has you damn near in contempt of court. So you need to check your attitude.
Judge.
All right, Mr. Sherbert, that's inappropriate for court. I'm going to ask you to not make such statements here. All right.
Cedric doesn't even crack a smile. Come on, Cedric, smile.
All right, I've executed the judgment, filing it with the clerk now. Both of you can obtain a copy of that judgment anytime later today.
Thank you, Your Honor.
Thank you both.
Thank you.
There you go. Yep.
I wonder how many holes he has in his drywall.
Okay, the next.
Okay, so this right here, if you've been watching my videos at all, Derek Tran. Derek Tran has been in front of us before. Unfortunately, he does not live up to his name in these videos. However, I was on the edge of my seat this entire video because the judge takes a long time to make a decision. And, I'm like, I'm biting my nails. I'm like, no, don't do it. Don't do it. So the judge does make a decision. And then they get to the end of the docket and everything is done. And then they're like, you know what? Can we just revisit Tran one more time? And I thought, oh my goodness, no, no, we don't want to do this. So I was on the edge of my seat, even though nothing crazy happens this time. It was still crazy for me.
All right, that's Mr. Tran.
Yes, Your Honor, this is Mr. Tran. At this time, I'm requesting that the court release him from custody, given that the competency evaluation has not been completed in the mandatory 14-day period.
Just in case you haven't seen Derek before, the first time we saw him was at his arraignment, and he kept saying over and over again, I plead guilty, I plead guilty, I plead guilty, I plead guilty. The poor, his poor attorney fought tooth and nail to disregard everything he was saying and keep the case rolling. Now, they did a competency evaluation on him in the past once before, and he passed it. I don't know how he passed it. I sincerely don't. So then he comes again, I think for a status conference or bond or something. He comes back in front, and just so you know, we're in Washington. So in Washington, the whole goal of the courts in Washington are to let people out of jail. So they want, the least restrictive means to a person in punishment. So it's not all that difficult to get a bond or get released from jail in Washington. So they asked for a second competency evaluation, and his attorney during the second one was like, well, can we let him go? Can we release him on bond while we're waiting for all this to happen? And Derek's like, I object. And she's like, wait, you object to being released? And then it goes on a little longer, and he's like, can I not participate? I do not want to participate. I do not want to do this. Can I object? And then he has to. So then at the end, he starts saying, "Can you release me?" It was so funny. So now he did have one other one prior to this one a couple days ago, but it was real quick. They just brought him in. They said we're waiting on a competency eval, and then he left. So I didn't record that. Nothing happened, and I don't think we need it for a complete list because nothing at all happened. So now we're here again, and we're going to talk about his competency evaluation and the mess that this is causing.
We requested that on July 5th, and it is now 16 days later. I've not received any information as to when that will be completed. So I've uploaded an order on motion as well as a new order for out of custody competency evaluation.
All right. City's position?
And Your Honor, the city is objecting to Mr. Tran's release on this matter. So the city does have a lot of concerns with danger of violent crime, intimidation of witnesses, interference with administration of justice. Mr. Tran has been before court multiple times for violating no contact orders or assault, all stemming out of the same two victims, which are his parents. The city has had good contact with the father in particular, who has told us that he does have grave concerns for him and his wife's safety. At one point, and this was, I want to say back in June, he informed me that both himself and his wife are homeless and living in cars because they did not feel safe being in the same house as Mr. Tran, who was living at their home. He reported that the defendant doesn't take care of himself. He apparently walks around the house, banging on things and threatening him constantly all night. He reiterated to the city multiple times that he is fearful that Derek Tran will severely hurt him or kill him. The city notes that the 14-day period is set forth by RCW 10.77.068. That is essentially, the 14 days isn't put on the court, it's put on the people doing the competency evaluation. It is a performance target. It states that the purpose of the act is to sustainably improve the timeliness of services related to competency to stand trial. The city oftentimes is understanding, and if it's not done by 14 days, if it's not a violent crime and the city doesn't have concerns, a lot of times we don't object to release. However, the city does have concerns here. The city notes in particular under RCW 10.77.068, the subsection 9 states that this section does not create any new entitlement or cause of action related to the timeliness of competency to stand trial services, nor can it form the basis for contempt sanctions under RCW 7.21 or a motion to dismiss criminal charges. Due to the above, the city is objecting to release and would ask the court to continue to hold him pending competency. And finally, this was a situation where when the second competency evaluation was ordered, I believe it was marked that defense presence would be necessary versus just having noticed that it's occurring. I believe that's because there were some concerns over the fact that he was found competent once, and then they raised competency again. But the city does believe that it is possible that that might be what's stalling. However, obviously, I don't have any information about that. The city just notes that that is one of the differences between the previous evaluation that was done within the 14-day period and the order for this one. Thank you.
All right, defense motion, so I'll let you have the final word.
Thank you, Your Honor. I would reiterate my request to release him. He was previously evaluated. He's been in custody for well over a month and a half at this point, a month and a half. He was evaluated the first time. I think he was largely non-responsive, and we felt that the evaluation was inadequate, as it sometimes is. We know competency is fluid and can change over time. We did request to be present, and we always have somebody available to let us sit in telephonically, so it's not been an issue. We haven't been contacted regarding anybody going down there yet. Your Honor, to be frank with the court, I haven't seen the city ask to hold someone in after the 14 days. 7 days is the target. 14 days is the maximum. I've sat in on a few True Blood panels. The fact that it's not done yet is concerning. I know that there's been a lot of improvement over the last few years, especially with the changes in the law for 1077 clients. The reason for the 14-day target is that people are significantly more likely to decompensate, get worse, not receive the mental health treatment that they need while they're in custody. I understand the city's concerns. The father of the alleged victim knows how to get a civil protection order and will often get those and use them when he feels like he wants to, and then let them lapse. Or
I really disliked that part that she put up, because if you've ever lived with someone with mental illness, I mean, you love them and you don't want to get them in trouble, and you want to do what's best. But it is scary when every night you're trying to go to sleep and they're screaming at the top of their lungs, or they go outside and they start screaming and banging around outside at 4 a.m. every morning, and your neighbors are sympathetic but angry, and you don't know what they're going to do. You don't know if they're going to hurt you or not. Sometimes they do get a little violent. That doesn't mean they're very violent, but you just don't know. So yeah, I believe that the father got a protection order before. I believe that, and I believe that he didn't want to, and I believe that he lifted it. But that doesn't mean that he uses it against him whenever he wants. I believe that he's just trying to figure out what to do with his son.
Or ask that they be lifted. That's been the case. I mean, it was the case a couple of months ago, and he let it expire. He knows how to protect himself. If he does not want his son in his house, he knows what to do. I don't know if there's currently a no contact order in this case, but if there is and he returns to the house, he knows that the police will be called and he'll be arrested. And so I'm asking the court to release him today based on all of that information. I don't think it's fair to keep him in custody for an undetermined amount of time as he continues to languish in jail cell.
All right. And the parties will have to remind me. I see there is an active protection order, civil protection order. I don't remember if the contact order was ordered in this matter.
I don't believe there was, Your Honor. Give me 1 moment.
All right, so I have some of the same concerns, although I may come to a different conclusion. I have concerns that he would be sitting in custody with speedy trial tolling. My other concern, however, is that there was an evaluation and he was found to be competent. And so I think what makes the most sense, because I think the amount of charges and concerns of the city in regards to victims are what the court weighs alongside other things, is to recommence speedy. The court finding that at this point, if defense wants to be present and wants another evaluation, but I'm not hearing that we can't talk to him or communicate with him, and there was a finding that he was in fact competent. So if speedy recommences, he's held justifiably, and speedy is allowing him the speedy trial, then I don't see the detriment to the defendant if speedy trial now is recommencing and he has the right to the speedy trial, barring defense saying we can't talk to him, we can't communicate with him, and given that there was previous finding of competency. So do you want to weigh on that, Ms. Nipples? Oh, you're muted.
To be honest with the court, I haven't encountered that. I know that the last evaluation applying to that he was competent. The court did not enter an order finding him competent. I've had situations where an evaluator has found my client competent, but I've briefed it. The court is supposed to consider the evaluation, but that evaluation isn't the determining factor in a defendant's competency. Large deference is supposed to be paid to the defense attorney's communication and contact with the defendant. This is somebody that I've worked with over a period of years, and I have substantial concerns about his ability to move forward in this case. If the court's inclined to restart speedy, That's certainly okay with me, but I would reiterate that a second competency evaluation was ordered on July 5th because of those ongoing concerns, and it has yet to be completed.
Okay, so my concern is I didn't hear anything to say that we've tried to communicate with him recently and we still can't communicate. And so I certainly am not suggesting that deference shouldn't be given to defense. I'm seeing the couple times that he's come before me, him communicate. I don't know at what level because I'm not asking a lot of questions. And so at this point, if you're saying there's been a recent communication where those attempts have failed, then that's another issue. But just the 14 days isn't determinative in my mind when there are other concerns and legitimate concerns on behalf of the city. So if you want to add some information to the record in regards to your ability or your office's ability to communicate with them recently.
We still have the same competency concerns. Those haven't been quelled based on his behavior last time I was with him in court, my communication with him prior to court. Every communication I've had with him since I've represented him back in 2018, and he's been found not competent or had all of his charges dismissed since then. I have ongoing concerns about his competency. The evaluator in this case was not able to, my understanding was he was largely non-cooperative, and so they kind of, when they do that, they gather information from the resources they have and make their best guess. I have ongoing concerns about his ability to assist in his defense.
Okay. All right. Well, unfortunately, this isn't the first time I've dealt with this type of issue, and my tendency would be to allow the grace until Monday, and request of the city, which I know they've done this before, is to get information from the evaluating agency with a date certain. And oftentimes, for whatever reason, I think we all can understand how that happens sometimes, is when the city or both of the parties encourage and say that the court is requesting this to happen and to have a date certain of when this will happen because of the expiration of 14 days. Sometimes then people get going and make it happen. I have real concerns about indefinitely sitting there. I agree with defense on that. I also have real concerns on the city side in regards to some of their concerns. So I realize this is not ideal. I'm fighting at least until the Monday calendar that good cause would exist to leave the bail in place, and then to continue to hold speedy trial and continue to request the competency evaluation based on the representations that defense counsel just added, and set to the Monday calendar to determine if the city can share whether they were able to reach someone a date certain, or defense could share. I'm not limiting to the city. If anyone can share that they were able to reach and obtain a date certain information in regards to the court considering further good cause continuance past the 14 days. I wouldn't be inclined to go too far past. I wouldn't be inclined. I think the most I've gone is a week or 10 days to allow the opportunity for evaluation when somebody is a dangerous risk, which is what the city's asserting. So I would appreciate if the parties can do what they can to find out date certain or any information in regards to it. But frankly, my other concern is they're coming tomorrow or they're coming Monday, and with all the concerns of the parties. Okay, so the court is going to find good cause to extend the timing requirement for evaluation to Monday, and on Monday, then there will have to be another finding of good cause, because I really think it should be on a very short leash as far as these findings, in fairness to Mr. Tran, as well as the community, balancing those two interests. Excuse me. Any other further record or notation need to be made in regards to the reset to Monday?
Just so the court is aware, typically when an evaluator is assigned, they reach out to us the week before the evaluation is set to take place, because we always mark that we would at least like to be notified. And so we're given, I plan to go down on this afternoon and we plan to have our assessment done on so-and-so date, usually a week in advance. And I would note that I haven't had any communication whatsoever from Western State Hospital, and none of the other attorneys in my office have either.
Okay, I appreciate that information. So that kind of leads to the conclusion that it wouldn't be by Monday or soon. I understand the information and how it's relevant to that.
So while I'm on the edge of my seat, waiting for her to confirm her decision, he keeps moving around, and I'm waiting for him to talk, but he disappoints me.
Give me just a moment. I'm just adding some language to the order. All right. We're still waiting on a rating on this matter. I'm just confirming, folks.
I believe he was previously arraigned. One moment. Yes, he was arraigned back on June 14th, and then competency was raised at June 16th.
Okay. It's just a matter of choosing which hearing, because it doesn't allow a checkbox for a motion hearing, which really would be most appropriate, but just trying to keep track of what stage we are at here. I amended that to the Monday hearing date. And, yes, I will add a out of custody should be posted. August 1st at 2 p.m.
You know what? I'm not even going to answer this question.
All right, anything further on this matter from either of the parties?
No, Your Honor, thank you.
Not from the city.
Okay. All right, Mr. Tran. Thank you.
And I was happy. I was relieved. I'm like, okay, he's going to stay in there until he gets his competency eval and, maybe get some real help.
I think that's the last matter, so...
Your Honor, if we could just briefly readdress, if we could briefly readdress the Tran matter without having to bring him back on record.
Okay.
It does look... Go ahead.
No,
He's still here. Oh, my done? I thought I was done.
No, you're done. You're done.
Oh.
All right, I don't know if you saw him before he turned his head away real quick, but we had him on before, and he's the one who just could not stop talking. And it was just little mumbles, mumble under his breath, no matter what anybody said. So the judge muted him, and he still kept talking the whole time that he was muted. And nobody could hear him because he was muted. So he took off his shoe a couple times, and was putting his foot up to the camera to, to try to get attention back on him with no, you see how these three people work. That's how this court works. There's no paper. Everything's on the computer. They're all working together on the same docket, on the same piece of paper. Everybody signs, and then they move on. They don't move on until it's all signed and ready and done. And he wanted attention, and nobody was giving him attention. The judge was just talking, and the lawyers were talking. So we got to see him again today. And this is the second time that I've seen him since that first foot in the camera hearing, but nothing really happened. He didn't even really mumble a lot. It was just quick, and we're waiting on another hearing. He has a protection order. He's not allowed to see his son. I think his son might be an adult son, so it's not like a little kid or the rest of his family. So we're just waiting to see what happens on that.
Okay.
We're talking about somebody else.
Got it. Okay.
All right. Thank you. Thank you, Ms. Chloe.
You're welcome. Have a great day.
You as well.
And I just wanted to address, just to re-note the cause numbers 23L 83518L 1530 Derek Tran. It looks like the city, and Ms. Hansen, I can allow you to make the record, but from the emails that she was sending while we were on the record, it doesn't appear that either that the order was ever sent or ever received. And so that makes anything happening by Monday extremely unlikely, but there was a request to send the order to Western State Hospital today.
That's correct, Your Honor. I was hard at work reaching out and getting more information as requested.
I like the promptness. I like the promptness.
Full credit and appreciation for that. As on a Friday, the earlier you do it, the more chance you have that success. Go ahead.
I didn't actually know who to email, so I just emailed the last person to email me from there. So, and they did tell me they actually are not in receipt of that order. It's now been emailed by Ms. Atkins. So I think that was apparently the issue with the order. Right. With the reason why I don't have the evaluation. So the city does note that underneath RCW 10.77.068, it does state that there's the maximum time limit is 14 days as measured from the department's receipt of the court order, or a maximum time limit of 21 days as measured from signature of the court order, whichever is shorter. So in this case, it would be the 21 days from signature, which would put it at Wednesday.
Last Wednesday or this coming Wednesday?
This coming Wednesday would be 21 days from the date that it was ordered.
I see. Okay.
I think it's, just briefly, Your Honor, I don't think that the evaluation is going to get done by Wednesday. And I think we probably all know that, given that it's just been sent over today and they're going to have to find someone that's available. We're barely making the 14-day mark as it is, right? We're having to release people pretty often because they're not meeting 14 days. The goal is 7, which I don't know that I've ever seen that happen ever in 10 years of practice. And the maximum is 14 days. This is a huge issue that it wasn't sent, and it's bordering 8.3B that he's been held 16 days without it being sent additional. I would propose at this point, if we want to recall him, I would ask for him to be released in the court. I wouldn't have an objection to the court imposing a no contact order as a condition of release, because I know that's not been ordered yet. I just don't think it's fair to keep him in custody, given that it was an error made by the city that's held him in for over 2 weeks additional at this point. It's hugely concerning to me.
City's response?
And Your Honor, the city understands, it does seem that the RTW does contemplate, however, a delay from the signing of the order to receipt by the DSHS. So the city would just ask for what's contemplated by the RCW, the 21 days from signature of the order to the next court date. Thank you.
Well, all right, so unfortunately, I don't have the original order in front of me. So the original, I'm looking through the docket trying to figure out when the original signature was, and that was on the 5th, July 5th.
That's correct, Your Honor.
On this second email, okay.
Oh, and Your Honor, sorry, Officer Brown is defense contemplating Mr. Tran coming back out, or?
I guess it depends on what the court is inclined to do.
Well, you know, at this point, based on, for lack of a better term, a bit of a comedy of errors here, I guess I would like some more legal authority, and I understand from the defense perspective, and I have concerns myself, of the holding of somebody. It complicates everything that this is a second evaluation, and if I reviewed the initial evaluation, I don't remember it, and so you know, the findings at this point, there was a request for a second evaluation. We've already had discussion about competency in regards to the first set of findings, and so it seems like the only law I have in front of me right now is the RCW allowing 21 days from signature. And what I believe would be a due diligence, justice argument in response from defense, which I'm not suggesting that's not valid. I'm trying to articulate the two sides of the issue. And I guess I would like a little more authority for the courts to be directed as to exactly what's supposed to happen in this situation. Because at this point, the legal authority I have is, albeit not at all the way I would like things to proceed, is to not have an order go as immediately as possible. That isn't to be clear that that's what I do believe in. I do believe also that it allows a certain period of time and for him to be evaluated under the statute. So I guess I would just like more legal authority if because of the delay, he were to be released, especially since this is a second evaluation and already an evaluation finding some persuasive evidence of competency, which, like I said, I don't know all the facts and circumstances. So do the parties want to leave it on Monday and present an argument? With some legal authority?
Yes, Your Honor. I have a substantial amount of legal authority that I'm able to relate to the court on this particular issue. I would note that the fact that it is a second competency evaluation shouldn't sway the court one way or another. I think having communication with the client after that first competency evaluation and with the knowledge that competency can be fluid and that an evaluation can be requested at any point during the proceedings, another evaluation or a first evaluation, I don't think that should be taken into consideration, but I would like this to remain on Monday so that I'm able to provide additional authority to the court.
Okay. I think that would be the best procedure at this time, is to allow additional authority and therefore have the best legal decision made in regards to how the case should proceed. Okay?
Thank you.
All right. Thank you. All right. Thank you, Ms. Foley.
Well, we made it to the end, and Derek did not get out. He's going to stay in there at least until Monday. I don't know how long the normal judge is gone for. I don't know what she's going to do. She's tough, but she lets people out because that's what they do in Washington. And you know, the prosecutor does say that that 14-day rule shouldn't be the only you shouldn't put a motion with just that one rule and expect that one rule to carry the day. The law says that you can't just use that one rule for that. So that helps. We'll have to wait and see what happens on Monday. I don't know how long it takes to get a competency eval there. It sounds like 2 weeks. So that sounds like that might be pushing it for all the judges. But we'll see if they keep him in there for 2 weeks or if they let him out. We'll see. So I have to go wash out my eyes because of some of the things I saw in this video. You can't really unsee them. They're there forever now. So I hope you all have a great weekend, and I will talk to you next video. Have a good night.